And thanks to Simon especially also, and to his colleague Jane Williams, who had originally hoped to be here too. At one level I felt it was important that Jane wasn't here, because Simon was able, I think, to give her the right credit for all the work that has been done by Jane alone and with her colleagues. And it's really a fantastic initiative, and I think it feeds in very well with the kind of presentation I'm going to make this afternoon also, which at some level is a call to arms in the context of reforming child law in Ireland, and I suppose it fitted also in the context of the conference, but also the work that we're trying to do with the clinic. So what I want to do this afternoon is two things. One is to make that case for child law reform in Ireland, explaining why I think reform is necessary, and outlining why it's important. I also then, secondly, want to explain how and why we should be doing this together, and that neither one of us alone can manage this task, but that it is a collaborative endeavour, be it collaboration or conspiracy. I'm open to both. And those are the two elements of proceedings that I want to try and pull together for you in this session. I want to start with, I suppose, the basis that Irish child law, to an extent like child law in other jurisdictions, is a neglected area. It has, of course, been very slow to emerge. Our main statutory frameworks are very recent in time, with the exception of the Guardianship of Infants Act. The idea that we had no statutory framework for our child protection system until 1991, in fact it was not fully enforced until several years later, though we had no proper statutory system for our education system until 1998, and though we had a very old-fashioned, century-old provision for our criminal law in children, not until 2001 was that reformed. So our main statutory frameworks are very recent indeed, and while they have benefited from the international imperatives that I'm going to outline to you in a second, it's clear nonetheless that this has been a very slow process. Ireland has been very late in coming to the table on these issues. There is no doubt, and I think many of the people who are present will be familiar with the context of the constitutional provision, the extent to which the constitutional framework has in some respects been the factor for the delay in legislating, but has nonetheless, and I suppose in particular, it has framed the legislation, and the way in which we have legislated has been largely determined in the broad scheme of things, if not in the detail, by the Irish Constitution, its focus on the rights of parents and the role of the family, and the absence of certainly autonomous, if not express, rights for children. What is important on a positive note, though, is the extent to which international imperatives have proven influential. We still care what is thought of us in international fora. We still are concerned that we're putting our best foot forward when we're before the Committee on the Rights of the Child in Geneva. We ratified the Convention on the Rights of the Child without reservation or declaration in 1992, and we have been party to and involved in the development and, to an extent, the implementation of children's rights standards at an international level. We can see, and it was touched on in two different presentations this morning in terms of both Hague and Brussels regulations, the extent of European law influence in this area, and really how that has proven to be the driver significantly in certain areas. We're also seeing, to a less extent, but I think Connor's paper drew out the potential of this also, the role of the European Convention on Human Rights, the fact that we are not just a party and can be brought before the European Court as a respondent, but also the role of the ECHR in the domestic context. And so, additional to that, of course, the Council of Europe standards, Mariella referred to the guidelines on child-friendly justice, the drafting of which was chaired by an Irish civil servant, and in which there is always active Irish involvement at a European level, and others who've been involved in, for example, revising the Convention concerning adoption and so on. So I think the importance of looking at the positive influence of international imperatives is is clear. Nonetheless, and even though we have now got to an extent a reasonable statutory framework in the areas of education, of child protection and of juvenile justice, to name just three broad areas, I think we can safely say, however, that child-focused child law is still quite elusive. It is still not something that I think we can, a description that we can use really to the Irish context. And I'll explain what I mean by that in a second. In particular, I suppose, if we look at what the international imperatives tell us, and we've heard much of this this morning, from all of the international instruments, from the CRC, from the European Convention, and from the range of UN and Council of Europe standards, we can distill a number of core principles that again represent that international consensus around children's issues in child law. The first is the principle of children as autonomous rights holders, that children themselves are and have capacity to hold and to exercise their rights, to have those rights protected on their behalf when they're not in a position to exercise them themselves. The requirement to ensure that their best interests and welfare are protected, that their views are taken into account, that they have a right to access justice and to redress when their rights have been violated, and that they are entitled to child-friendly process and procedures. And those principles, summarise really the international framework and what we're required to do, but also I think what is the clear wisdom of not just the research community, as much research underpins these standards, but also the political consensus, what governments have managed to agree on at an international level. If we look at the state of Irish child law then, against this backdrop, if we look first of all at the best interest principle, it might come as a surprise to you to realise on reflection that we actually have no broad-based principle of this kind covering all areas of law in Ireland. What we have instead are very precise applications of the principle in specific contexts. It's not particularly relevant. For example, it's not expressed at all in the Education Act. It is there to a very limited degree in the Children Act and in the context of children who commit criminal offences. And in the context of public and private family law, it's limited to the courts in general, considering questions of custody, guardianship or access. So it's not a broad-based principle that really guides all of the actions that concern children. With deference to parental rights, I suppose it's framed under the Child Care Act. So we have certainly no constitutional principle, but no legislative imperative that covers all of the actions that affect children in this context. Similarly, I think we can point to certain positive examples in relation to the Article 12 principle, or the right to have children's views taken into account. But here we see a relatively weak, as I've described it, begrudging duty to consider the wishes of the child, falling far short of children's views, and also the caveats with various provision that it's where that's practicable, where it's appropriate, these limitations that are placed on what we will do with what children may or may not have the opportunity to tell us. And that is, I think, in stark contrast to some of the examples that we heard in the morning session in particular, about where the role of children in proceedings is much more secure. In education law, for example, again, just to give you a further different context, those rights are largely vested in parents. So rights in relation to school are not vested in the children themselves. They are vested, in fact, in parents, and parents hold those entitlements to appeal decisions and so on. So we have a limited appreciation, while what's there is welcome, very limited appreciation of those two core principles in those specific contexts. And if we look at the other aspect of this, in terms of our core principles really, the issue of children and justice, if we look at the concept of children as rights holders under Irish law, we can see through the statutes, at least, little if any expression given to children's own perspectives, their own rights, their rights to family support, their rights to contact with parents, their rights to education, with the exception perhaps of the Constitution. But this is not a position that is informed by children with capacity to exercise and hold those rights. we have still no definition of parental responsibility, and really we have family status dictating whether or not children will enjoy certain benefits or not. Children's capacity across a whole range of areas is quite muddled. We can see in healthcare a whole range of dilemmas that have real impact on children's lives in the context of mental health decision making, in the context of the ability to refuse medical treatment, to consent or access medical treatment over 16 years, notwithstanding what the law says. And then we have the contrasting position with criminal law, where we're happy for children to take criminal responsibility from the age of 10 with regard to very serious offences. So a very unclear picture about what Irish law really thinks about children's capacity. And I think also, related to that point, the fact that children are excluded from relying on the age grant under the equality legislation, again, gives you a sense of where children stand in the order of things legally. In the context and related issues of child-friendly justice, I think it's significant that children have no independent right to access court. So a child cannot litigate on their own behalf. They need an ex-friend to get into a courtroom, and in the cases in which that's not possible, we're reliant on the willing judge to perhaps allow counsel to intervene on their behalf. It's simply not acceptable, in my view, that we put those kinds of barriers in the way of children who are otherwise, in the criminal context, for example, considered capable of instructing their own counsel. We have little accommodation in the legal system of the special needs of, in particular, two types of children who are listed there: children who offend. In terms of the criminal process, very little adaptation is made. And indeed child victims, who still labour under very significant burdens, where they are, these two categories, forced, if you like, into often the criminal justice system. We have virtually no separate representation for children in private family law or in constitutional cases, and we have no, a really critical issue, I think, no statutory duty to expedite cases involving children. All of the other jurisdictions, like modern European jurisdictions, require the courts to exercise their due care in ensuring that cases involving children are heard as quickly and as efficiently as possible. You know, again, with that principle in mind that the children simply don't have the time to wait. When you look at the concerns that arrive at just, and some of these have been touched on already today, just the kinds of substantive concerns that arise out of this, a whole range of issues around adoption. Some of these were touched on by our colleagues last night: the absence of open adoption, the whole process of placing children for adoption, when that happens and how that happens, the use instead of long-term foster care, where children really spend considerably longer periods of time in care than they would in other countries. Again, where the absence of, Mariel described as sort of permanency planning, doesn't inform the system. And I think, notwithstanding the reforms in adoption law, the absence of any consideration really been given to the child's right to identity in both that context and in the whole area of assisted reproduction. Outstanding concerns, in my view. We could talk, I'm sure, about the inadequacy of the child protection system, frequently discussed and debated issues there, inadequate family support, the question of monitoring, how effective and robust our monitoring systems are, and the question of physical punishment, the fact that Ireland still continues to permit, or at least to allow, the use of the defence in those cases. And then finally, just to raise two separate issues, the questions of justice and detention for children. Two questions again here, where we seem to accept that children can be tried in adult court, in the circuit and the central criminal courts, with very little consideration been given to their age and different circumstances, and the continuing detention of 16 and 17-year-olds in St Patrick's Institution in the adult criminal facility. So the question then moves to reform, and clearly the need for it is very stark. And the question, I suppose, first of all, relates to what the consequences of our failure to reform child law have been. These are general, but they are true, and I think they will ring true with many of you who are involved in advocating on behalf of the rights and interests of children, both as practitioners and as academics, activists, or otherwise. the continuing failure to reform child law, ensure we have a robust family law and child law system that is fit for purpose, is that children's rights continue to be ignored or sidelined, continue to be denied priority in the legal sense. Children are continuously deprived of effective remedies, often facing walls of silence in terms of looking for remedies and redress. And that throughout the system, children face unacceptable risks and are, many would agree, I think, harmed by their contact with the legal system. So far from having a system that protects them, it forces them into a system which, in fact, is causing more harm than good. In my view, progressive reform of child law is essential for a number of reasons, and they are both, I suppose, theoretical and of practical importance. The first, clearly, is that the better advocacy and protection of the legal rights and interests of children. More generally, to ensure that the law and the legal system is fit for purpose. To avoid harm to children, at the very least, we should not be causing them harm by their interaction with the system in either criminal or in family law cases, and also ensuring that redress is available and effective when necessary. And anybody who's read any of the investigation statements from the Ombudsman for Children's Office will see the extent of the challenge that children face in this area in particular. And of course, there is a huge imperative coming from all of the body of research and evidence from right across the world, identifying what the key interests of children are, how the law should respond, and really keeping up, ensuring that our system, our legal process, keeps up with those modern approaches. I suppose moving on then as to how to achieve reform, there are clearly, I think, at least three elements that are relevant to this forum. The first, and this is the very least, is a documentation of issues of concern. And last night people will have heard, I suppose, the recording, the putting on the record of concerns around the way Irish child law operates, but also how law is framed. So this, I think, is a vital first step, that we document what these concerns are, and secondly then that we bring that into the public domain, raising awareness about the need for reform and about what form it should take. And then I suppose I come to the second part of the presentation, and that is how we combine research and litigation in order to achieve reform. Of course, the question is who is to undertake these endeavours, and here I suppose I'd go back to the point about the importance of collaboration. So the first is to highlight the roles of those, many of whom are in the room, legal scholars, as our job, a huge part of our job is the research and analysis of all areas of law, but particularly in relation to children. But also then our work as teachers, as tutors, and as supervisors of graduate work. And there's a huge body of work going on in the universities and all of the law schools around these areas. Clearly, as members of the legal profession, your job is to both litigate and to represent children and their representatives, and their carers and others who work with and for them. But there's also clearly beyond that a hugely important role for those of you who advocate and represent in broader terms, to be involved in public debate and discussion about these issues. And then, of course, having bridges and linkages with the broader children's sector. I mentioned the Ombudsman for Children, the children's NGOs, and others in the statutory and non-statutory sector, and crucially, of course, with those that have political responsibility. And I think we're in a very fortunate position with a reform-minded Minister for Children and Youth Affairs, and similarly a reform-minded Minister for Justice. And I think the window for achieving change in both of those areas is really vital to maximise at this time. So if I going back a little bit on what the Child Law Clinic is here to do, and I suppose why it was developed around this approach. It's certainly the underpinning or the underlying basis of the Child Law Clinic, that law schools have a vital role to play in all of this. We are, as individuals and collectively, researching child and family law. We are teaching child and family law. We are, I hope, developing student skills to question, to challenge and to advocate. And also, I suppose, as part of that, it's important to reflect the mutually beneficial nature of all of that experience. Lest anyone think that our students are these sort of silent receptacles of knowledge that we fill on a weekly or daily basis. It's a clearly collaborative process between students and lecturers in any law school now. The disadvantage, I suppose, of the Irish and also the non-professional law school is that we can't be involved directly in litigation. So all of the clinics that have developed around the United States, for example, all have lawyers, those who are being trained professionally to advocate and represent their clients directly. We can't, and so the model of the Child Law Clinic was developed uniquely for the Irish and the non-professional law school environment. Related to that, though, and on the plus side, I suppose, and the reason for collaboration and partnership is that legal practitioners, solicitors and barristers and others have that role in directly being involved in litigation and are central so to litigating children's issues and also to representing children directly. And so the clinic, I suppose, tries to develop the partnership based on those two contexts. The fact that law schools have both the capacity and the skill and the resources to research child law, to understand and to develop skills around that area, and the practitioners are those with direct involvement in litigation around children's issues. And so the idea of the clinic was developed with colleagues in the United States in particular, with a view to building the bridge between the professions and academia in a way that would advance the reform of child law, but also involving the quality of children's representation, ensuring more strategic development of child law in the courts, and then thereby, as a pedagogical objective, promoting students' awareness and giving the opportunity to be directly involved in these cases. There are, of course, in many jurisdictions, examples of where this approach has been successful in marrying research with litigation. And I think the most overwhelming case for it comes from some of the case law that's coming out of the United States at the moment in the context of juvenile justice, and some of you will have heard me talk about this before. The US Supreme Court, in a number of decisions in the last number of years, has relied very heavily on academic research on child development in deciding critically that the law, the United States law relating to the treatment of children in criminal law matters has to change. While these cases, Roper and Simmons was a challenge to the death penalty for under 18s, Graham in Florida was a challenge to life without parole for under 18s, and JDB, it should be JDB versus North Carolina, was a case concerning the Miranda rights, the duty on police officers to take age into account when delivering the Miranda rights to juveniles. These, while they are very specific issues, have nonetheless represented a major shift in US constitutional law, informed by two parallel developments, as I said. One, the neuroscience research on child development, which has made the case overwhelmingly to the Supreme Court that children are different and require different treatment. And secondly, that is related to and underpinned by the Convention on the Rights of the Child. So in my success, in my experience, this is a win-win situation. The Child Law Clinic has a number of committed, skilled legal researchers at its disposal, and it is willing to put those skills at the disposal of those seeking to litigate and advance the law in children's cases. The model is pretty simple at that level. The students gain practical experience of real cases, and they get to make a social contribution. As often is asked of me, they don't, certainly not at the moment anyway, get academic credits for their involvement in the clinic, which has an interesting impact on how they involve, I think, themselves on a completely voluntary basis. The lawyers, on the other hand, of course, get to use the benefit of students' research and skills, and also get thereby to advance their clients' interests. And so that has, as I said, a win-win outcome for both the students and those who are working in the clinic on the one hand, and lawyers seeking to advance children's interests and rights on the other. In terms of, I suppose, to give you some flavour of the kind of work that we've been involved in to date, we have been involved in cases on a national basis more than a local basis. We've had a number of cases which have dealt with issues like, for example, the right of children to enjoy contact with their siblings, information sharing between family and criminal courts and the limits placed on that, the limits of the in-camera rule, where we've developed argument around the in-camera rule itself, and also the arguments in favour of a more progressive approach. The critical issue of special care, we have ongoing involvement with respect to both availability of those places, but also the nature of that placement. And the treatment of children in detention, in particular in relation to the ongoing problems with children's rights in detention. And I think also critically it's important for you to know that beyond the cases that children, beyond the cases that the clinic works on, there are additional activities the clinic is very centrally involved in. 3 clinic members, Amy Coleman, Emily Bartholomew and Anne-Marie Brennan, recently worked on our first amicus brief on separated children, which was sent to the Inter-American Court of Human Rights. We also are involved in writing a guide, the Law for Children, the Know Your Rights Guide, with the Irish Council for Civil Liberties and the Children's Rights Alliance. And of course, we organise seminars and events like this one as we go through and see the opportunity, I suppose, for funding to support what we're doing. So the details of the clinic are there. This is a service to be put at your disposal. It is, as I said, a win-win for everyone involved in terms of the promotion of progressive child law reform, and despite today's being a free event and supported by the Irish Research Council, I would also say that all and any sponsorship for this free service is gratefully received. Thank you very much.